Hey folks, Joe Valley here. Welcome back to another episode of the Quiet Life Podcast. Today we've got Steve Weigler on the podcast. Steve is the founding attorney at EmergeCounsel. I used Steve in trademark, kind of a battle that I had with a large publishing company when they didn't like me filing the trademark exitpreneur. He was invaluable in helping me through that process, guiding me, counseling me, suggesting things that you would not normally hear an attorney suggest, mainly because it wasn't in his best financial interest in the short term. So a really straight shooter that helps with, getting all of your business documents together, helping his clients make sure that everything is buttoned up, and talking to them all throughout their journey through an eventual exit. And he's had a lot of clients that he started working with 6, 7, 8 years ago that are now exiting, that have been with him the whole time. And now he's working on their stock sale or their asset sale and working on those agreements. And he's there as a counselor, as a friend, as well as the attorney. And he's very, very reasonable. I want to say that straight up. He's not your typical attorney because he's an entrepreneur first and foremost. Actually, first, I think he was a litigation attorney, and then he was an entrepreneur, and now he's started EmergeCounsel as well. Great guy, very, as I say, towards the end of the interview, very humble, very soft-spoken, but I've seen him battle, and man, the tiger comes out when he battles. So just because he sounds like a super nice guy doesn't mean that you can walk all over him. Let's jump into it. Steve Weigler from EmergeCounsel. Here we go. Steve, welcome to the Quiet Life Podcast, or welcome back, I should say. How are you?
Well, always good to see you, Joe.
Same. So we're going to talk about a whole bunch of different things today, but why don't we start with you giving the folks that are listening a background on yourself and what you do?
Sure. So my name is Steve Weigler, and my background is both as an entrepreneur and as an attorney. I started many years ago in criminal law practice. I was a prosecutor in Miami, and I really—
That's not how we met, just for the record, folks.
No, I know hardly anyone from my past career, but I really, learned trial skills and learned which I think is a basic framework for lawyers. Like, you have to know that everything that could happen in a business setting, that could be a thing going to court, and really thinking from the perspective of, hey, what's a worst case scenario here? How would a court look at everything? And so I had years of experience in that, and then decided to be an entrepreneur, and started it was a company selling data and predictive analytics to school districts. And I did that for about 8 years, and started from not knowing anything about anything related to business, to building the brand, to building the assets, to raising a lot of money because we sold to school districts and the cash flow sucks. And to negotiating advertising contracts, to doing international deals, to investor discontent, to diluting myself out of the company, the good, the bad, the ugly. And through that, I was able to successfully exit, at least for myself. And I thought to myself, with my wife's encouragement, saying, even if we have money, you can't sit in the basement the rest of your life. I was 45. Started a firm focused on helping entrepreneurs, especially in growth areas, to build their businesses without making the mistakes that I made as an entrepreneur.
Very cool. Let's hone in on that term you just used called investor discontent.
Yes.
I want to hear your experience with clients that have had investors, and because they felt they needed to raise money. I had a conversation with somebody the other day. He asked me out for coffee. Lo and behold, he opens his laptop and he gives me his pitch deck trying to raise money from me. And good guy, but I don't think it's the smartest thing for him to raise money. It wasn't a whole lot of money that he needed. And now he's made some connections and is going to wind up doing a deal with getting some funds from the SBA. Another friend of mine who's been on the podcast several times, sold for a lot of money, built another company, ended up taking on some venture cap money, Steve. And once the ink was dry, they went from being really great guys to being total a-holes and very difficult to work with and made his life kind of miserable. What do you see in terms of things that you absolutely need to do in terms of, making sure that if you're going to take on working capital money and from your own personal experience, how to make it something that's going to be good for your heart and soul as well as your bank account?
Well, I mean, I think you hit on some good points. I think venture capital, it's not that even the worst venture capital, it's not that they're bad people. It's that they have kind of a job to do. And that job is to invest money and grow that money very quickly and exceed what the norm is. And they know that they're going to have companies that aren't going to make it. So exceed what their normal average is. And if you feel like you're that kind of company, number one, have someone like you or someone like me give a second opinion on looking at the numbers quantitatively and looking at the pitch. Are you really that kind of company that's going to succeed? Hockey stick, gazelle, whatever you want to call it, where it goes like this. 99% of the companies I work with are not gazelles. They're strong companies. Not all of them, but many of them are strong companies with strong ideas, strong balance sheets, strong cash flow is okay. Every company has its strengths and weaknesses, but they're not gazelle. The concept's not gazelle. Especially in e-commerce, it's usually a proven concept, and they could be selling a commodity, branded, which is why I focus a lot on trademark.
Yeah.
But it's not a gazelle, so it's not even a discussion we should be having out of the starting gate.
So only if your business is growing like crazy, hockey stick kind of growth, then venture cap makes sense in your view. If it's 10% year over year growth, 15%, 20 even, not really where you want to take on money.
Well, and a lot of times I can't imagine that they would want to take you on.
Yeah.
And so a lot of times it's just a waste of time. So the kind of equilibrium is to find how you can bootstrap, and even if it's going to be sleepless nights, bootstrap as much as possible, and then figure out how to supplement that. Is it friends and family for an equity piece? Is it, taking out a loan as unsettling as that can be? And then frankly, really looking at your business and figuring out what you want out of it.
Yeah.
Because a lot of times the entrepreneur doesn't even want a gazelle. Like that's.
And you're working with a lot of entrepreneurs now in terms of, based upon your experience, you're not just their trademark attorney, their, legal counsel for all sorts of different things, but you're also mentoring them a bit in terms of, their ultimate goal. And, in the process of getting your business sort of firmed up legally, what is their ultimate goal? And you're working with them more. I guess what I'm saying is you're not the typical attorney that's going to, get them a trademark. You're also counseling them on other things as well, in terms of business in general and what their goals are. Yeah.
Yeah, I think it's interesting because I guess it's after having some business experience, I know that the last person most people want to talk to is legal counsel. Like if you see I remember when I was my own CEO, I had to talk to an attorney at like 2:00, and I'd be looking at, all right, have a cash flow meeting, have a meeting with a client, or a customer, whatever. When I look at that attorney meeting, I'd be like, oh, can I put this off until another day? Do I really have to talk to the attorney? So when I started this firm, I got that. And I didn't want to be that attorney. My primary goal is to really kind of look at where are you? What do we need to do to get you from point A to point B? And point B usually is exit, or at some point for an increase. So it's to increase your value. And so looking at it through that lens, yes, when I talk to clients, and I don't really charge for the consultative, like to talk about where the company is, that should be really on my dime, to figure out what is this client, and first of all, build a relationship where they're not like call and think that the phone charges are running. That's always something I hated too. So really get to know the client, what their needs are, and build that kind of independent bridge. Because a lot of times, and Joe, I think you've had it where you have C-level meetings, and you're meeting with those people almost every day, your CFO, your CEO, your COO. The attorney isn't in that line of communication usually. They're a separate conduit for you to talk about what really the issues you see, and do kind of a um, separate line of defense to make sure that you can be successfully get from point A to point B.
What are those things, right? So everybody thinks their company's fine legally. They think they're all set and they're not going to be any issues in the transfer of the business.
Right.
What are some of the things that people have to make sure they've got absolutely buttoned up as they march towards their eventual exit?
Sure. I think and I usually see this at the M&A table, is looking at what a potential acquirer is going to look at. Number one is they're going to look at governance. And so they're going to see, hey, do they have, okay, they formed an LLC in 1996, and the LLC, they never had an operating agreement. They never had documents showing that they had annual meetings. They never showed compliance with state laws. They never showed that that they have adequate capital accounts. They never, all those things are hugely important, because the acquirer is going to take on the liabilities. A lot of times it depends if it's an asset sale.
Right.
But
if it's an asset sale, that doesn't matter. But if it's a stock sale, that's where it counts. Yeah.
yeah, absolutely. And so, and I would think a lot of times you're going to get more, there's going to be some value in having adequate protection in your governing documents.
You know where I think there's value there, Steve? It's almost intangible value. And that is that the more you buttoned up, you're doing things the right way, just in terms of governance, the more intangible value there is, because the buyer, the acquirer of the business, is going to believe that you're running a business well, and they're going to trust you more. It's silly things like that. The more confidence I think a buyer has in the business owner that they're buying the business from, the more money they're going to pay and the better terms they're going to give. I see it over and over and over again. So just that alone, I think, is important in terms of governance and having things set up properly. And it's not hard to do.
And I think, Joe, in your experience, it's like you get an offer letter or a LOI, and the LOI says the anticipated payments like $29 million. That's,
it's a good day.
It's a really good day. But, and the entrepreneur, which usually is my client, is like, all right, well, let's get this stuff over to them. And then you start looking at it, and it's like, look at the due diligence list. It's all your governance documents. It's all your annual meeting documents. It's your financials. It's your trademarks. So what happens is the $29 million, that's their leverage. If this isn't nice and neatly packaged, it's not so much that it's going to kill the acquirer. It's that they can use it as a negotiating point to drive down the value, even though it's not. It could be a legitimate concern or not legitimate. So it's really, I look at it sometimes as a packaging thing. And so when I see a client starting to get robust sales, sometimes we do it virtually, but we have a virtual annual meeting that I buy dinner. So if you want to be my client, you'll get dinner. Or I'll have it shipped in because we're virtual. But we just go through it so we can have an annual meeting, so we can put it in and just keep the books so that we can just hand it over and there's really no issues. Right. But in those governing documents, a lot of times during the journey, you have entrepreneurs that partner up or need some kind of financing with maybe a passive partner, and they get in fights. And that's not unusual. Or one partner, I have a case right now where one partner won't sign conversion documents to a corporation, which would be tax advantageous, because he's trying to basically extort the other partner, like, sure, I'll do it if you give me $100,000 to just sign this document. And so really, a lot of times you see operating agreements or corporate bylaws that are relatively complex. It's relatively complex because the parties are relatively complex. And so you really have to know, that's what a good attorney, a good business attorney should help you do, is really figure out, well, what's really the tea leaves here? What's the lay of the land you're facing? And so when I talk about like needing to understand the client, it's understanding, just like the deal, when you get finally to the deal, it's understanding a lot of intangibles. And so nicely packaging is a nice way to say, check off non-issue. The documents are a non-issue. The brand is a non-issue because you have a trademark portfolio. Now, is that trademark portfolio bulletproof? Probably not. Most brand portfolios aren't. But is it nicely packaged in a spreadsheet that shows that we have the logo, the name, that we thought about international protection because they sell in Canada, or that's all things that we want to make sure.
This is a dumb question, but if you've got the trademark, why isn't it bulletproof?
Well, because a lot of times if you're looking at it, multiple SKUs or ASINs, and it's say you trademarked it in, toilet tissue, and you're selling personal lubricants or something, something that isn't in the same category. You didn't update it. You don't have the trademark portfolio of, like, for example, Coors and Miller Coors or something. There's always ways to poke holes through any of these strategies. But basically, and it's why I start with my TotalTM program. It's like, what does someone need at the very beginning? Not very much. They need governance documents, and they can be very basic, and they need a trademark. Like, you need to protect your brand, because I think at sale, well, the most intangible value is the brand. I mean, everything else is tangible, how much money you're making, what the product looks like. So I just think, you can go overboard on trademark protection, but you don't have to. And so somewhere, I work with my clients somewhere kind of in the middle, where it looks really good. We know that we've built a basic wall, but it's not, the wall that Trump thought he was going to build on the Mexican border. It's not like, it doesn't have to be that wall. So it's kind of, all this is kind of a balancing test of what is going to pass muster, what makes sense for the entrepreneur, what's not going to cost a ton of money. But at the same time, it just can't be like, go to LegalZoom, pull some documents and go for it. That's going to cause more problems as the company grows. And especially at the M&A table, they're going to discount the value of the company or walk away. I've had that case.
You've had that happen as well.
Yeah. Or, I mean, the governance or the documents were so screwed up that they started devaluing so much that no one could get the deal done.
I've seen certain categories become an issue because of the lack of testing or documentation. Let's say that somebody's selling a product in the children's category, and there needs to be testing done there. I've seen deals fall apart because they didn't have what they needed there. Tell me more about the Total TM program. Is it just trademark, or is it just a little bit of everything?
Well, that was my start to really make price predictability, because again, clients don't love being billed by the hour, and they really, I get uneasy when I'm talking to someone that's you're on the phone and you think that the clock is running. So TotalTM is our basic trademark program. That kind of, what I did is I said, what do large law firms do to protect big brands? And what processes do they do? And why do they do it? And so a big part of that is like, you have to do a detailed search. And a lot of times entrepreneurs kind of cut that step out. So if you Google like file a trademark, $395, yeah, you can file a trademark just like I can file a corporate tax form. But to do it right, you need to have a really detailed search to see, well, is Miller Coors, let's say you started a beer, it's called Malaysia. And it's going to butt up against Miller. Well, it might not show up if you just look on the USPTO, but you're going to get a cease and desist letter from Miller. And so at that point, you want to know that long before you file the trademark, because you're building your brand over that. The trademark process takes almost 2 years. So the kind of getting in the heads of the USPTO, you have to do a thorough search. That's what large law firms do. That's what we do. And so it's a process, and it's, we have it at a low price point because between using technology and systemizing the process, we're lower in price than the Amazon IP Accelerator, and it's much more thorough, and it's as quick. So it's just kind of and so that was our first product. Then we're doing internet. The next systemized product is productized is called an international IP plan. So we kind of take a look at you have to understand the client. Like, so for example, if you were selling, let's use the beer example. If you were selling non-alcoholic beer and you're selling in the United States, Canada, and you have a unique logo and you have a unique way to explain it, well, that's a copyright and a trademark and 2 trademarks at that point. You might have a formula that you want to protect. Anyway, we map that all out, and we do it in the most economical way to get that protection. And then we have that nice package that we hand to a broker like you at the M&A table. So it's like, at that point, it's like, check off the box. Like, we're not going to talk anymore about IP because that's taken care of. You've taken the time to put that together, but we've taken the time to put together systems. So it's very low cost for our clients to have that kind of packaging. Just like if you went to a large law firm and you were Miller Coors, you would have the same kind of thing, but it would be pages and pages.
You mentioned
20 attorneys working on it.
You mentioned taking your product internationally. Do you have to get when you're filing a trademark in this situation, is it a separate trademark copyright for international versus US?
It is.
And do you file them both at the same time generally, or do you not?
Well, there's some strategy involved, but there's something called the Madrid Protocol where we can, within a certain amount of time after we file, take that application and file it internationally. And so we kind of need to know, again, from the client, well, what's your plan? Like, what's your supply chain coming in? So is it coming from China to the United States? Is it stopping anywhere? Do you sell it? And then reverse, are you selling in Europe? Are you selling in Canada? And then let's look at the economics of all this. You don't want to spend all your money on trademark. And so let's look at what would be the most cost effective. Is it using foreign counsel, which we have a huge, that's what I've been doing for the last many years, is building up relationships with counsel in almost every country that any of my clients would want to sell in, to do foreign filings, or do we use the Madrid Protocol? So there's a lot of strategy involved. And then the last factor is cost. So we try and, between technology and understanding the client and systemizing, we're able to really put it in a very quantifiable and easy to understand and very low for what it is cost point. And so that's really my project, and we're plugging away at it. And so now we're doing the same thing on corporate. We're really looking at strategies and systems to make sure that the client gets the best cost and best service.
And is all of this geared towards protecting a client's business and making sure they are not getting knocked off and being infringed upon by either somebody else in the same country or another country, be it China or somewhere else?
Yeah, I think that's a good reason to seek trademark protection or any kind of IP protection. I think it's a combination of what we just talked about, which is creating value and being able to establish that value at the M&A table. So I guess the point is, even if the client could care less about it, the acquirer does. So, or even if they don't care about it, they're going to make sure that they act like they care about it if you don't have it, so they can lower the price. The second thing is yes, especially in the e-commerce space, knockoffs are a huge issue. And um, even large corporations don't have a bulletproof solution to police against knockoffs. The problem I've seen with a lot of my clients, which are much smaller than, say, Miller Coors, I just keep on using that as an example, is that if they get knocked off, that's a real big issue for the client. Like their sales drop, their ability to, it's almost like you've lost a substantial amount of market share. And so to do the basic prophylactics, which we're talking, a $1,000 to $2,000 process at most, is really like, that's the ticket to entry to protect your brand. And if you can't do that, or you don't think it's important enough, well, you're taking a really substantial risk. To me, the risk analysis is.
And having this full package together, is it helping clients that are selling on Amazon get knocked off and their account suspended? Somebody else can, claim, infringement when you actually have all the trademarks and things of that nature. Is just having this all buttoned up, does it help sort of defend yourself against Amazon just making a decision too quickly, suspending the account, and then you having to prove it that you're actually the owner of the brand?
Yeah, I mean, so Amazon, as arbitrary as sometimes it can seem, they have systems in place to acknowledge their legal responsibilities. One is if you send in a trademark registration or a copyright registration, it's they have to realize, or they have to recognize that it's per se evidence of ownership of the brand or the item. So they don't really have much choice in that if you show the registered trademark. If you don't, I mean, really good luck. It's going to be really, really difficult. You basically have to get a registered trademark. That's the beginning. The question is like, how many? And that's my job to make sure you get as few as possible and still make them effective.
Are you helping clients when they decide to eventually exit? Are you working with them on, drafting a letter of intent and the asset purchase agreement of the stock sale, acting as their counsel in that situation?
Yes, I'm doing more and more of that. It's been fun because at the beginning, well, my clients were all started, and now after 8 years, they're a lot of them are hitting the M&A table, and it's been really fun to be a participant in that. I can't. I mean, sure, I could do charity work and go and work at a hospital or something, but this is I can't tell you the warmth in my heart that I see watching these companies grow, and it's been really, really fun. I think the thing as an outside advisor that I see is, there's an initial excitement, and you see the number and they're excited. And then they go through the process and realize that, what was written on that paper or what has to be negotiated is not that easy. It's easier said than done. And so again, really working with them at the early stage. A lot of these clients have been with me for a long time, or we have a relationship, that it's nicely packaged. It makes it just that much easier. But there's a lot of times, Joe, there's a lot to be negotiated. And there's a lot in that LOI, which is, in your experience, isn't it usually coming from the acquirer?
Well, yes. In our situation, we always are looking for certain things that are going to be presented in the offer, because our standard letter of intent has certain features in it, and we extract those features. And if we're going to get 10 offers, rather than present 10 letters of intent, we break it down into bullet points. This is the basic framework of the offer. Let's put it all in the same format so my seller can digest them equally instead of trying to understand the legalese of 10 different letters of intent. So I don't want people that are making offers to give me a full letter of intent. I want to know the purchase price, the terms, the closing date, the non-compete period, some basic things of that nature, the transition and training period, things of that nature. And then get it all the same. Here's your 10 offers. Here are the basic points of all these offers. Let's, shed some of them. Let's move the rest to the top and focus on the ones that you want to respond to and negotiate with. And oftentimes the surprising thing, Steve, is it's not always the highest offer, right? More times than surprised. I shouldn't be surprised anymore, but it's, Joe, I really, that it's a big number, but the guy doesn't seem trustworthy and I don't want to work with him. I don't believe him. Let's talk with this person over here and see if we can just get them up a little bit and work with them instead. Because it's very personal, these exits, and it means a lot to people to get this close, and they're almost there, and they need to get the rest of the way through. So the key points in a letter of intent are critical. But we've developed a strong letter of intent over the last 17 years now, something like that. But it's usually the asset purchase agreement. Due diligence can be tricky and painful sometimes, depends upon the parties involved. But the asset purchase agreement, if someone gets the wrong attorney negotiating their asset purchase agreement, they could negotiate themselves right out of a deal, asking for things that are completely and utterly unreasonable. And the worst possible situation is when a seller or a buyer has their mother, father, sister, aunt, uncle, cousin, professor be their legal counsel. I had once one where the seller, his father was an attorney, his mother was a professor at a law school, and his fiance was in law school, and he was in law school. The deal fell apart because they were completely unreasonable. This was a kid at 24 years old getting nearly $1 million while he's in law school, and it completely fell apart because he was completely unreasonable. So you got to have good counsel to have good logic and reason inside the asset purchase agreement or the stock sale as well. Wouldn't you say? You've done these a few times.
I mean, here's what I've noticed in my transactions is I'm aware that there's a LOI being negotiated. I think there's an art, and it's a business deal, and there's an art to negotiating an LOI. A lot of my deals, I've worked with your firm on some deals, and I really kind of get the points, or there's been times where I've drafted the LOI, but I get involved at the time of, okay, let's take a look at what the LOI is. Let's see if there's any potential road blocks. Like, I think a big one, Joe, right now is transfer of inventory. Like, when is the money going to transfer as opposed to the inventory, especially on an Amazon FBA? Because Amazon has the keys to the castle. They can transfer the accounts, but the parties have to close a deal, and so there's a third party involved, and so there's a trick to put money in escrow, etc. So usually that's a little sticky point, and then you kind of get the idea of who the parties are involved. Is it a big roll-up company versus because attorneys look at it like, who's the opposing party, even though you're trying to close the deal. But is the opposing party a huge company, and what's your leverage, and what's their closing process? And then so that's, and then I see a LOI and I know documents are coming. At that point, when the documents come, yes, the APA is like tremendously going to be attorney driven, but the lens to look at is like, is this really a barrier, or is this something, and what negotiating position do we have? Like,
should be
I'm not
none.
going to blow up a deal.
It should be very little, right? The negotiation. I don't like it when attorneys and accountants come in trying to renegotiate the deal for no good reason other than they think they need to renegotiate the deal. In my view, what attorneys should be doing is negotiating the finer points of the asset purchase agreement. The liabilities, things of that nature, not the value of the business. That is done in the letter of intent. So
exactly. I'm right there with you.
Yeah. We do a lot of coaching of our buyers, right? We represent the sellers, but unless we get the buyer's mindset right, the deal's not going to close, right? And getting a letter of intent is only, the first step in the process. You need to get all the way through to closing and have, money transfer hands. So we really want to pick the right buyer because we want to see that it closes. And the buyers have to behave. I was at a Rhodium weekend up on stage at one point, and somebody, asked a question of what it takes to be a great buyer. How do you win a deal over somebody that is an all cash buyer? And the answer was just don't be an asshole. It's pretty simple. Be a good, likable person, present a fair offer, think about what your seller wants and how it's going to make the most sense to them. Sometimes it's just reassuring them that, the staff is going to transfer. You're going to take care of his or her people and be a good human to them as they've been a good human to them. That's often more important than an extra, $50,000 and knowing that the deal is going to close, especially because you got to work with them after the sale during the training and transition period. So there's a lot of counseling that goes on before we even sign a letter of intent. And then when you've in a situation with multiple offers, you get to choose your buyer. And then, you're sort of training them on how to behave and hopefully educating them on what type of attorney to hire. And, we refer people out to you. We refer people out to others as well, because the attorney can make or break the deal. You bring in the wrong attorney, like that kid's father, and they ask for completely unfair, unreasonable things that no seller in the right mind is going to accept, which could be liability forever type of thing. And the deal just falls apart. So good attorneys are critically important, Steve. That's why you're on the call.
I think through my business experience, it's like there's business terms and there's legal terms. Business terms, that's not like, of course I'm gonna say, wow, that's a really good amount of money, or are you sure that if I feel that way, I might opine, but
I'll be on the call, with the other party,
but not to the other
I'll
side.
be like, "What the hell do you know about it, Steve? You're an attorney.
Yeah, that's probably true.
You're not an M&A guy.
So I should probably
get out of the way."
I should get out of the way. But when it comes to the legal terms, so for example, again, the areas I see, escrow is always something that the deal's like 99% done. We're ready to transfer the money, and no one really ever thought of it. So the second thing I see a lot is
let's touch on that first of all. So here's what should happen is that you sign the asset purchase agreement, money goes into escrow, you transfer the assets, money is released from escrow. Not that complicated. Am I missing anything?
But in the one I have right now, where I was retained after the deal, it says the guy pays the money and it says transfer all assets. Then the parties are scared that the Amazon won't accept a listing transfer or the account transfer, and they're in litigation.
We've never had an Amazon account not transfer. Sometimes there are hookups. No. Sometimes there's not hookups. That's the wrong terminology here. Hiccups, right? Sometimes there's hiccups, but it always transfers. But it's weird.
I was deposed as an expert yesterday on this subject. And then the other thing is representation that you guys could never care less about is representation and warranties. So
we care about those. Those are the things that can kill deals, the reps and warranties.
Right. And it becomes very legal. And I didn't mean that you don't care about it. It's just like, it's very legalese.
Yeah.
And so, and a lot of times they're demanding a lot of indemnity, the buyer, that really in good conscience, I would love to just sign off on the deal, but that's something that we really have to negotiate, because you don't want to close a deal as a seller and the next thing you know, be sued for a violation of a rep or warranty.
Yep. It's tricky. It gets really, really tricky there. And having somebody that's not an expert explain it is really not a good idea. So I'm a big advocate for hiring due diligence firms during due diligence and attorneys to negotiate all of the aspects of the deal. Reasonable, logical, entrepreneurial driven attorneys like Steve Weigler. There you go.
And the one last thing I got all charged up about this is, there are sharks out there, and I can't say it's with any deal I've worked on with QuietLight, but where it's a good reason for the seller to sell. The buyer's a shark, and they're going to take any little thing and make it a big deal, which is, again, why due diligence and making sure you just either run it by an attorney or your business advisor and make sure it's nicely packaged and answers the question. And everyone's aware of any, on your team, of any potential issues. So we don't deal with that later once it blows up.
100%, right? That's why our client interviews have gotten ridiculously long in some situations, because we want to ask every question the buyer's going to want to ask, get the answer in advance, present the full package after they sign a non-disclosure agreement, so that after you sign the letter of intent and while they're negotiating the S purchase agreement or they're in due diligence, they can't say, but you didn't tell me this. Oh, yes, we did. It's right there in the written package that you've had access to forever. And we've got these 6 recorded phone calls. Let's go back. You call them sharks. We call them something else. And when they behave that way, they often wind up in a particular category in our CRM with warning labels on them, so that inevitably, every time we have a new client that's selling a business and they've got multiple offers, they just get one. They're going to say, well, what do you think of this buyer? What do you think of these buyers? And then we look in the CRM, what's been said about them by the rest of the team and how they behaved and how they acted. And we convey that information. 99 times out of 100, they're great people, great buyers. It's that one shark that's a problem. It happens. This is not unique to Quiet Light. Every M&A company, whether it's digital or non-digital, the team, when they get an offer, in our situation, I see this goes out to Twist or email, whatever. Hey guys, got an offer from so-and-so. Has anybody had any dealings with them? So they got one person asking 14 other advisors their personal experience with this individual if there's no notes on them in the CRM. So you've got to be a good buyer. So we try to prevent all the negative stuff that you're talking about as much as possible by coaching and training buyers all along the way, having them get a good attorney like yourself. But inevitably, that one time out of 100, it's still, and it might be more than one, it's still really, really painful to think you're going to get a certain number and you're a certain amount of time away from closing, and somebody else is just being a shark, as you're calling them, because that's the way that they've grown up and that's the environment they've been in. They think that's what they need to do, and they're just not good people. And it causes a lot of angst and anxiety, and it's your livelihood on the line and your family's well-being, and they're just being sharks. So it's unfortunate. It does happen sometimes, but the better attorney, with starting with everything buttoned up from governance on to somebody that has your type of experience, from both a entrepreneurial experience where you've got that mindset, but then one that also deals with lots of asset purchase agreements and stock agreements all along the way. And I've seen you negotiate. I've seen you negotiate, Steve. You're very soft spoken. You're a sweet guy, but I've seen the tough side of you as well. So, and sometimes
it's my job. It's not, I don't take any pleasure out of it. Or sometimes I do. Anyway, and the flip side is, Joe, it's like, it's so much easier to do a deal when you're doing most of that work. A lot of, sometimes if a client's coming to me or they've grown and they think, oh, the buyer comes naturally or the seller comes naturally, whatever, and they don't work through a quality organization that's focused on this field like you, that's a lot of times where the meeting of the minds isn't really there, no matter how you write the LOI, because there's been no vetting, there's been no due diligence analysis, etc. And it's not that it can't be done. It's like, it's a lot more like for me to get my arms around.
Yeah, it can be done. And sometimes people get lucky and they find that right buyer on their own and they've worked with a good attorney and it works. Unfortunately, more often than not, it doesn't work. But look, everybody's going to choose their own path when they choose to exit. At the very least, if you're not going to work with an M&A firm for the process to protect you against all the negative things we just talked about, do 2 things, right, Steve? Buy the Exitpreneurs playbook so you understand the process, and hire a good attorney like yourself so they're defended along the way. You don't have to, if you're not going to have an M&A advisor, that's okay. At least do those 2 things so you've got some knowledge and experience, as opposed to just learning everything you can from one source. Any other thoughts on that before we wrap it up?
Well, I think you hit on the entrepreneur playbook. I really, after I read that, I kind of reversed engineered my thinking, which is you have to think with the like, of course, it's like a lot of my clients are early stage and they come to me and I'm like, well, let's get the basics done. And they really have no, like, you have to start with the end in mind. And so really it's reverse thinking about what usually people want to exit at some point. They like to grow. Entrepreneurs in general like to grow, and at some point see the fruits of their labor be paid off. And so I really think looking at the points in the entrepreneur playbook and then working backwards on what you need business wise, and especially for me, what you need legally at various stages is crucially important. You're not going to get it all done at once. You don't need to. You don't, even your financial books, you don't need to have 18 different charts of accounts if you have one SKU. Like, it just isn't. But really thinking about what that exit's going to look like, what you're going to need to achieve that exit, and then working on the legal framework to get there, you're going to end up saving a ton of money as opposed to just stumbling along on the journey. So I've been referring to it constantly in my own practice to build my steps to get from point A to point B.
Appreciate that. Steve, how do people find you? What's the best way to get in touch?
So I offer, my philosophy is I want to get to know everyone I have a professional relationship with, and I don't charge for initial consultations. I usually don't even charge for phone calls for my clients that have I have a relationship with. It's www.emerge, EMERGE, counsel, COUNSEL.com is our website. Mine is SWEIGLER at EmergeCounsel.com, and everyone has my telephone number. So it's 1-800 or 1-888-EMERGE-0. And you can schedule for an initial consultation. I'd love to get to know all of you. I'll be at Seller Summit if anyone's there. And I'll have a bunch of copies of Joe's book.
Hey, and you can buy Steve's book there at Seller Summit as well. Steve Chu, that is.
Yeah.
And at EmergeCounsel.com, there's a great resource section as well, folks. Blogs, ebooks, presentation, video, newsletter. Check it all out. Steve, thanks for your time. I appreciate it.
Always good to see you, Joe.